Okay, folks, we're back in session.
Got two missing.
Yeah, I see that. Okay, ladies and gentlemen, where we left off was item number 14. So I'll declare us back in session and declare the recess completed. So item number 14 is consideration of a property owner initiative petition for an amendment to the comprehensive plans, future land use plan, etc. Mr. McCoy.
Well, good evening, Mr. Chairman,
McCoy,
members of the board. Yeah, Mr. McCoy is out on a conference, so you all are stuck with me today. My apologies. So just as a refresher, the applicant requests an amendment to the comprehensive plan to change the future land use map designation for their two properties from medium density residential to conservation. That's at the heart of what we're hearing today. The applicant's requesting this amendment in order to place the property in a conservation easement with the Blue Ridge Land Conservancy on their two properties. Virginia State Code requires that before this happens, that any easement is in line with the county's comprehensive plan, which right now it's not because it's medium density residential and not conservation. So that's the whole reason why we're hearing this request today. Again, this was heard, a majority of this presentation was heard last week, the kind of the fundamentals of what they want to do and why they want to do it. You all elected to table it so that you could hear from representatives of the Blue Ridge Land Conservancy. As you all know, they are here today. They have already spoken earlier today, but I would invite them to come down and speak if they have any further information that they would like to provide to you all.
Good afternoon again. We don't have a presentation prepared or anything like that, but we're certainly available to answer questions if you all have any questions about the comprehensive plan amendment request or conservation easements or the Blue Ridge Land Conservancy.
Anybody have questions?
I'd like to find out is, as far as a water line that would maybe go through there, that's not going to bother that conservation easement whatsoever. Is that what you're saying before you brought that up in the very beginning? Could you elaborate on that?
Correct. Yeah. So the conservation easement does not, it can't limit the county's ability by law to, negotiate with landowners to purchase right-of-ways or obtain right-of-ways by eminent domain for utilities and those sorts of things. There's some language in there about if the landowner chooses to work with a neighbor to extend utilities onto a neighbor's property that are private, there's some approval from the Land Conservancy in that regard, but we can't, by law, we don't have the power to say yes or no to that or to get involved. If there were some issue that it would in some way damage the conservation values of the property, we might, bring those to the board's attention. But again, it wouldn't change the board's authority in any way, shape, or form.
Okay.
From your point of view, from the conservation easement world point of view, is that a disqualifier, or is it does it affect your internal considerations for a conservation easement? And what I'm referring to is a utility easement or a utility line in place?
No, it wouldn't. I don't think so. In this case, the main conservation values of this property are protecting the water quality in Tinker Creek, and then the farmland on the lower portions of the property closest to the road, and then the mountainside on Tinker Mountain, protecting that habitat, protecting that view for the residents of the county, and the experience of the hikers along the Appalachian Trail.
Anything else from board members?
Glad to hear that. I was glad to hear that.
Oh, yeah, yeah. Mr. Lockerbie, do you have anything to add to it? I'm asking this because we discussed some of the legal implications this morning, but I think they're all straightened out.
Yeah, we had discussed earlier, I've dealt with conservation easements in a lot of different contexts. And one of the things that you will sometimes see in them is either an outright prohibition on utilities being put across the property, especially to serve things on the property, which of course that I don't think that that's something that the board would be concerned about, but I know that the board is concerned about linear utilities crossing this property because most of this area of the county is planned for future higher density residential. So one of the things that I know planning staff and myself had discussed was providing that was putting in here that in order for this change to be made for this property in this particular area of the county, that the ability of the lease to convey a linear utility easement for water or sewer along this parallel to and near the route that currently is used by the sewer would be carved out such that it did not require compensatory dedication of other property in return. And that's not super unusual, but it is something that you need to write in, or then you wind up in a situation where sometimes, for instance, Western Virginia Water Authority could wind up having to basically condemn out a conservation easement, which creates all sorts of IRS problems nobody wants.
Okay.
I do have our template utility language that I could share with you just so you could see what that is. It's pretty standard in our easements. And it does say that the grantor of the easement to the landowner would still have the ability to convey that easement in the future for a utility.
Tell us again what that is. I didn't hear.
So that's our, I just gave them a copy of our easement template language addressing utilities. And it does state that the landowner or the grantor of the easement retains the right to grant a utility easement over the easement or over their property.
Sorry, Mr. Chairman. Is everybody sitting here staring at me while
I'm watching you, Ray.
while I underline and read this this document? I have to admit, I'm not going to be able to think this all the way through while everyone sits here and stares at me.
Do you think that we should table this till the next month, or how do you think that we're comfortable in what you're going to be saying here in a second?
I think that what we had discussed earlier today would be just fine. This is sort of the standard language where you wind up in, frankly, you wind up in a fight with the conservation easement holder and the IRS sooner or later in at least a small percentage of situations. And that's exactly the concern that we had and that Western Virginia had.
Okay.
So here's my procedural question. Our duty is to adjudicate the land use, the comprehensive plan amendment.
Right.
and then we're done, is what I'm hearing. But I'm still not clear on who picks up the verification of a conservation easement on that land. And I,
Honestly, nobody picks it up except the commissioner of the revenue, because he has to then assess it for land use tax value.
so like we said earlier, it's strictly, or it's fundamentally an agreement between two private parties,
Correct.
but it will show on our land use plan maps as a conservation easement.
Right. And the issue that you have as the Board of Supervisors is that you're trying to find a way to thread the needle of protecting the conservation values of this property while also trying to preserve the fact that the vast majority of this area of the county is and would continue to be foreseen for future development.
Sure.
Okay, thank you. Anything else, Nick, from you?
No, staff doesn't really have anything to add other, in addition to what Mr. Lockaby, has stated. It's just for you all to decide whether or not you feel comfortable with an amendment to the comprehensive plan, to the future land use map of the comprehensive plan.
Okay.
Mr. Lockaby, I do believe in their motion, there could have been some language added, I guess, in relation to any possible future utility easements, given the sewer line that runs through the property. That is something the board could consider, correct?
It is. I know that I gave that language to Mr. Clinton before the meeting. So. You have that language, Mr. Clinton?
Oh, I'm sorry. I didn't hear what, I couldn't hear.
I'm sorry. There was some language that that we had bounced back and forth before the meeting. Do you have that handy?
In the conference room? Or-
With respect to the comprehensive plan
Right,
amendment?
but was it a piece of paper or is it,
Yeah, we bounced it back and forth electronically only, I believe.
say again?
I believe we only exchanged it electronically.
Yeah, well, I'm sure I have it, but I'm not sure I'm going to be able to pull it up with my laptop in the conditions.
I do have it. I would be happy to read it aloud for the record. It's whatever the board would
If
like.
you could pull it up for us to see,
Can you do that?
could you pull up your email? Or,
I have it pulled up. Are you talking about sharing it to the screen or just for me reading it for the record?
Yeah, you can read it.
Okay. So just for your consideration, the language that Mr. Lockaby had brought up earlier states verbatim, no conservation easement on the property shall prohibit expansion or dedication of easements for linear utilities parallel to the existing sewer line along Catawba Road. That's verbatim the language that you all
And-
may consider as part of your motion if you choose to approve this request this afternoon.
Now, if I recall, I made a mistake because it's not actually along Catawba Road. What is it along, Gary?
It's just along along the current utility there.
The current utility
It is
line.
adjacent to the current utility.
And
And there's also a well apparently on that property.
but the conservation easement couldn't prohibit the continued use of that well if necessary.
So it's just along the current utility use that's there now. So if you ended up having the possibility of an easement in the future along with a construction easement, if who knows what might end up happening in the future, that would end up allowing another utility to be placed adjacent to that. That's all that's being asked for in reality.
and Nick, are the landowners are in agreement with that language? I mean, that's a piece of this.
Yeah. We need legal ramifications.
What?
We need legal
Yeah.
representation.
There, something written out that should have been maybe sent ahead of time that I'm supposed to know about? I don't know. This is language that you had in your executive session, that I'm not privy to,
No.
I'm not sure.
It was not. It was before that. So do you want to restate it, Mike?
This was language that came up because the Western Virginia Water Authority realized that they were going to be cut off from serving any property to the west of this property if this were a conventional, or that they were going to wind up in a situation where they'd have to condemn a conservation easement. And it was my understanding, and perhaps I'm mistaken, that you had no, again, this was relayed to me by third parties, that you had no issue with the idea that if the easement were widened by 10 feet in order to put in an underground water main, that was not going to be an issue to you. But if it is, then speak up. I'm not trying to tell you what to do or what to say. I'm just telling you that this was an issue that came up in the last, not even 24 hours, 22.
Yes, I have heard this through a conversation with Mr. Clinton. I think initiated by you, Mr. LaRue, and then the water. Anyway, doesn't matter. I have heard that there's a concern, I think everyone's been pretty clear that you would not be stopped from allowing a water line to be run alongside the sewer line, which is quite close to Tinker Creek, by the way, which brings its own potential hazards to my mind. But so as long as the conservation easement wouldn't have no issue, I don't know that we would have an issue, and that would be something to negotiate. And I think that's what everyone is talking about. But the easement itself would not stop it. And I think that's all we have to understand today. Right now, it's just in theory. There is no water line planned. It's, if you'll look on your own, comprehensive plan and the maps, there's water, right? There's water on Catawba Road. So there's no way they would be, what did you say, cut off from providing water? Yeah,
The broader issue is that a conservation easement is perpetual. If we were talking about 20 or 30 years, you might easily be able to say that. But in 500, I don't know where I'm going to be able to find this organization. I don't know, in order to get their permission.
I hope we're
so
all
on
here.
and so forth. There's still going to be somebody providing public water here.
I have a
We don't know
feeling.
who's going to be holding this conservation
figure it
easement,
out.
or if they still exist.
Sure, and there may be other options.
Yeah.
Many, many years ahead of now for water and sewer that have nothing to do with our property right now. So you'd have to jump ahead in your mind where this development might sprawl out to and how you might find water that has no need for the conservation easement.
I think that one of the things is it may have grown larger than what the intention was, is that the intention is to allow, make sure that an option, this would be an option of putting in a line of some sort, whether that was water, sewer, fiber, whatever, a utility could potentially flow adjacent to what's already there. Or let's say in some point in Mike's example of 500 years into the future, and there needs to be an increase of the size of what's already there. That would end up being allowed. And that's what it seems like that was being spoken to earlier. So it doesn't seem like it's a large issue at all. And if it's
Right.
incorporated
I
with
think it's workable.
with the condition of what the board is before them, and let them make the decision whether they want to provide the conservation easement or not.
So if I understood that, I worry that we're equivocating a little bit, aren't we?
I don't think so.
We're opening the door to future alternative ways to get water from the same point A. We're not.
No,
That's what it sounds
no,
to me.
sir. I think that one of the issues is that folks have been talking about water. It may, who knows, it may not be water. It may be an increased sewer line size or something into the future. So I would just think that the best way to get the maximum amount of options would end up saying utility rather than water line. There is no planned water line there. That's as of today. That's for
But
certain.
who selects, just hypothetically, maybe 500 years? Who selects the option? Who says, yeah, let's do that option or who says, let's leave it like it is?
I think that it would end up probably coming down to just exactly the way it is today, Mr. Clinton. It would be financially driven about whether that's the best option or if there's another way that would be a better option. And there may very well be. This is absolutely not saying that this is what would happen. This is just making sure that that option is still available.
If there is an existing sewer line easement, that's correct.
Mhm.
And we were just discussing this, at first blush, I don't think that's something that the Land Conservancy would object to including in the conservation easement. Of course, it's a negotiation with Mr. Lee and Mrs. Paulson Lee. But, we're generally not in the business of opposing utilities that are serving the public need. So, as far as that's concerned, if it's a determining factor as to whether or not the conservation easement conforms to the comprehensive plan, I mean, that is language that I don't believe we would oppose putting in the conservation easement.
That's all. That's all.
The language is in the agreement. I think that's what we're all trying to get at.
When you,
I think that's what they're
Yeah,
doing.
we just decide.
I think that's what they're doing, Mr. Mike.
What they're saying, and it's already within their kind of general language that we start with when we craft this document. We craft it specific to our hopes and our hopes for the future, well past all of us, and that this is actually a gift, not something I'm trying to take away. We're trying to offer it for future generations, open, natural space. I think I've made that pretty clear.
And there are very, very few properties that we conserve that don't have some kind of pre-existing utility easement on them. We work with Dominion and AEP if they need to put up larger power poles, larger power lines, whatever the case may be, because they've got that right in place. And very seldom do we feel that it impacts the conservation values. In fact, there's 2 power lines running through Carvin's Cove on the other side of the mountain. And I don't think anybody claims that their experience is diminished in any way by having those there.
In the foreseeable future, it is your organization that handles those negotiations with the utility companies. The Conservancy does that.
We'd be involved, but typically it's between the landowner
Okay.
and the
Okay.
right. Mhm.
I'm still a little nervous about how we're throwing around the word negotiation. I guess when we're speaking broadly, it might be negotiating another easement or a revision to this easement. I'm not real sure, but what worries me is negotiations break down. Then what? We go back to where we are now and we have a single easement? Or am I worried about something that's not?
Well, good.
Sorry, I think it's kind of the situation that you're in right now. How you operate anyway. As a new idea comes forward, then you have to think about what utilities are going to be needed. And then you have to talk to the private landowners who will be affected. This is no different. So if something hypothetically comes up down the road, then you'll talk about it. That's what negotiation, I think. It's a form of ideas and methods.
But whatever the topic of the negotiation is, it can't obviate our ability to transmit water over the property though.
Correct.
Yeah.
Yeah.
And
And there are all kinds of technologies that come up that, there were conservation easements have been allowed in Virginia since the late 1960s. And no one, for example, could envision cellular towers at the time. And for many people, especially rural areas, that's their only source of the internet. It's vital for emergency services, all sorts of things. And so easements are amendable. They're meant to be adaptable. And the bottom line with the conservation easement is what serves the conservation values of the property. The conservation values are the things that make the property worth protecting. We've talked about those, the view, the Appalachian Trail, the forested mountainside, water quality in Tinker Creek, those kinds of things. So ultimately, that's what the driving determinant is what's going to serve the best value or the best interest of the conservation values in the easement. And that's actually in the state code, directing courts of law, if it ever came to that, that's what the judge is to look at, is what protects the conservation values. But like I said, we're not in the business of trying to eliminate the ability of the Water Authority, who's a great partner of ours, to serve the citizens of Botetourt County with water and sewer. That's not the case at all.
Thank you. Anything else? Mr. Baker, I guess it's to you now. We have an action for two amendments, I guess, and there are amendments to two separate parts of the comprehensive plan.
Mr. Chair, I do believe it's one motion for your consideration today. It should be in your packet.
It is. I just said, yeah. I'm just handing
It's
it over.
yes, it's two motions.
Second.
So there's one comprehensive plan map amendment.
It's the draft motions, and it's either to approve it or deny it. The comprehensive plan.
But there's
amendment.
only one motion.
Right. Yes.
We're either going to move to approve or move to deny, or we could move to table again,
Right.
but it's one item.
Okay, well, I'll make this my district, so I'll make the motion. We'll get a second, and we can discuss it further if need be. I move that the comprehensive plan amendment for the property of William Calvin Lee be forwarded to the, well, that was the planning
that was the
commission.
thing.
I move that we approve the comprehensive plan amendment to approve the comprehensive plan amendment as indicated in our package. Okay, it's been moved and seconded. Is there any further discussion?
Just one point of clarification. I want to address the comment by Mr. Rule earlier that I was tipping our cards and our hat when asking last month about the number of properties. My actual reason for doing that was to get some scope. To me, it would matter if there were 10 houses versus 100 houses. I was trying to get some order of magnitude of if this property were developed, what would that be? Because I thought that was an important fact for me to, as I was considering this and really hearing it for about the first time thoroughly. So that was my reason for asking that question. And I appreciate the office for filling me in on what it could look like if this were ever developed as it is currently scheduled. So that was the reason for my question last month. Other comments?
Okay, the matter lies before us. Any further discussion?
No.
It's been moved that we approve the amendment. It's been seconded. All in favor indicate by saying aye.
Aye.
All opposed? Motion carries and the comprehensive plan amendment is carried. Thank you, Mr. Baker.
Thank you very much.
Thank you.
Feel like we should pop a cork or something.
You're going to pick up smart scale?
Yes, sir.
Okay. Oh, excuse me. Mr. Patterson, did you have something you wanted to say on this other issue?
Yeah.
Go ahead.
I could proceed if to the next item. Okay. So good afternoon again. This should hopefully be more straightforward than the item that we just heard. Before you is a resolution of support for our 3 smart scale applications that we are working on, that completing and that we need to complete by August. County staff are working closely with the VDOT and our consultants from EECOM to develop applications for funding for 3 separate transportation projects in the county for round 6 of smart scale. As part of that application process, we need to have a resolution of support from the Board of Supervisors, which is what you all are hearing today. One thing I would like to make clear is that cost estimates for all three projects are not fully decided yet. That's part of what we're working with VDOT on and our consultant. But any money, any changes to those costs, we're applying for state money, meaning any changes are not going to hit our budget. It's not going to make our budget increase. It's not going to make anything more expensive for the county. So I just wanted to make you all aware of that. You all had summaries of the three projects in your application packages, and then past communication with staff. So I'm happy to answer any questions that you may have. Otherwise, if you all would like to take a vote to support this resolution, that would be great.
Well, congratulations on getting this far on those applications. I mean, I think to me, it's pretty clear if we go forward with it, obviously. I am personally concerned about, well, two things. Do you think that we are selling this aggressively enough in our resolution? And the reason I ask is, now it may not be this way anymore, but I know there used to be a triumvirate of, well, more than three even, considerations like economic development and safety and, you know, that come into the higher level concern, higher level approvals for smart scale.
As far as I'm aware, for every other past smart scale project, we've had one resolution of support for all of our smart scale applications. As far as, you know, the strength of the applications, the projects themselves, I would say, especially the Super Street, we personally on the staff level feel that it's in a great spot. For instance, we were just awarded an additional $5 million of funding from the Transportation Planning Organization. Staff put in a lot of work to make that happen. This is new funding that we haven't had before, so that's going to make our application that much stronger in the eyes of those who are looking at it once the applications are complete. So hopefully that answers your question.
Okay. One thing, and just one item that jumped off the page at me is, I'm just looking at my notes now, not as the actual resolution, but I think toward the end, maybe in the third or fourth paragraph, we use the word possibly, like this could possibly put us in a competitive position. Man, if it were me, I'd use a stronger word than that. Don't you want to? And you could take that up yourself, you and Ms. Pendleton. Possibly cast doubt on it to me. Minor issue, I'd think about it though.
It's my understanding that it's been kind of the draft language that we've used in the past. It's standard VDOT language, and anytime we have something like this, it's, you know, you avoid speaking in absolutes, you know, if at all possible, right? Because it is an application. We cannot guarantee that we're going to receive full funding as much as we would like to, but, you know, we had the support from you all is kind of the critical, it's the backbone of everything that we do. So that we have to have that.
Afterward, use the word possibly.
What was it?
I'll take it up however.
Yeah, I mean, we can modify it if need be, but I think that we're still able to get the support, still able to get what we need today, right?
I would just jump in and say that if the scoring criteria, the robust and very complicated scoring criteria had anything to do with how well we were writing the resolution or anything, we got a great team here. We would write the best daggone writing to help us get that, but that doesn't have any impact on the scoring criteria, but we can certainly modify it, take that word out, make it a stronger resolution if the board wishes us to do that.
Well, yeah, I don't know that we need to vote by the board because they're not looking at it, but take a look at it yourself and see if that wouldn't be more convincing. Thank you, Mr. Baker. Oh, we have to vote on that. It's been moved and seconded. So all in favor of proceeding with the request for 3 smart scale projects, please indicate by saying aye.
I'm not sure we had a motion.
Did we?
I
thought we
don't think
did.
so.
I'll make that motion though.
We've got one now.
We have a motion now.
All right, it's been
Good,
moved and seconded.
Yep.
Any discussion? All right, all in favor of proceeding with those three applications for Smart Scale, please say aye.
Aye.
Aye. All opposed? That motion carries. Thank you, Mr. Baker.
Thank you.
Ms. Pendleton is standing by. This is a consider amendments to the Botetourt County Code concerning litter control.
Thank you, Chairman. Good afternoon again, members of the board. This article, Litter Control of the Botetourt County Code, was adopted in 1983. The provisions regulating inoperative vehicles have been in place since at least 1986, and the provisions relating to grass and weeds have been in place since at least 1987. These amendments do not add to or alter longstanding restrictions on inoperable vehicles or on grass and weeds. So I'll say that nothing that was unlawful yesterday is proposed to be, nothing additional is proposed to be unlawful with the adoption, if you so choose, of these amendments. So again, no changes in what is lawful or unlawful are proposed by these amendments. The proposed amendments were really meant to address two concerns. Historically, county employees have enforced provisions of the article for decades. The amendments clarify and explicitly provide that the county administrator or his designee, which is common standard language that can be found by researching other codes in our adjacent and surrounding localities, that the county administrator or his designee may enforce provisions of the article. It removes ambiguity that could be a basis for any challenges that we could potentially face in court. Enforcement of Article 4 is available through the courts only, resulting in lengthy and potentially costly litigation, not only for the county, but for any party charged under the ordinance. The availability of administrative enforcement that's proposed mirrors that of other county codes. As stated last month, nothing in the proposed amendments prevents or alters the sheriff's office ability to enforce the provisions of the article. Without the amendments, community development staff will be required to discontinue its enforcement activity, and enforcement will become the exclusive responsibility of law enforcement. The sheriff has indicated that resources do not permit his office to actively or consistently enforce these regulations. No new positions are or have been or are proposed to be created, and no changes to current process are proposed. As stated last month, again, these were just merely changes to continue a process that's already in place and give us one additional tool in our toolbox that's consistent with other ways that we regulate the county ordinance across the county. And if you look in the amendments that are proposed, the entire code changes, there are very minor changes that are marked in red that are notated in the ordinance. Everything that's in black has been in place since the 80s. Again, with a few minor amendments that were made to clarify. Prior to a few years ago, there were no specifics on regulating certain details. So that's an amendment that has changed. The only amendment that's changed since the 80s that has helped us. So that's going to conclude my presentation. As a reminder, the required public hearing was held on June 25th, and you all voted to table this item until July. I'm happy to take any questions that you might have at this time, and I thank you.
So with all that, would you just succinctly say what will be different Monday morning?
Since last month, community development has not been able to enforce any complaints that we've received on grass and weeds complaints because of the tabling, because the ordinance does not specifically give county staff the ability to regulate or to respond to high grass and weed complaints within the residential and non-agricultural districts of the county. So what would be different would be that if the ordinance was passed, we'd go back to the way that we've been doing things since the early 90s, and we would be a resource to citizens who have complaints in the, again, non-agricultural areas of the county related to high grass and weeds complaints.
Can you tell us a little bit about what resources, if any, we have available for someone who may be ill, may have been in an accident, can't mow right now? If there was a complaint against them and it's truly not their fault, what would happen when that came to your office? Are there resources we can offer?
Absolutely. We have a great connection of folks regionally and locally that we work with. There have been several instances in which we have been able to help a property owner who does not have the means to take care of their property or to do those types of things that already are considered unlawful. Time is another avenue that we have. We're a small locality, we're a neighborly locality, and we have the ability to help people. We have the ability to work with connections that we have through our nonprofit partners. With the Council of Community Services and others, we participate on a regional housing network where those folks come together monthly. We were able to connect a property owner who was unable to really living in almost condemnable conditions to get new replacement windows and those kinds of things just by connecting the dots with the resources that we have and the connections that we have. Those are always our first resource. We also heard people say, well, have you talked to your neighbor? Well, a lot of times we do ask that question. Is that a conversation that you've had? And folks are and more often than not willing to step up and assist in the instances where you have a situation where they may not have the means, the physical means or the monetary means to take care of it. We have time on our side. We have the ability to say, we will connect with our resources. We'll look at this in another 30 days. Again, we're really managing the nuisance or the public impact to health, safety, and welfare. So when your grass grows up to a point that you have snakes and other things that are impeding other people's property, it's at that point that we might seek further remediation. But again, the majority of our complaints, we do work month in and month out with folks just looking for resolution and again, looking for compliance. It's not penalizing.
And we touched on this last month, but can you explain the impact of this change or these changes on agricultural equipment? How is it going to impact farms that have tractors and dump trucks and all things sitting around?
Yeah, it's not going to. This particular section of the ordinance, again, we've talked about tagged vehicles, right? They need to be licensed and tagged. And what we can see from the zoning office and from the enforcement of the community development office, the state code enables us, also protects private property in such a way that if we can't observe it from the road or from potentially a complainant's property, if they give us access to do that, then that's not an enforcement that we would go forward.
Ms. White, and additionally, as far as what this goes for, it actually decreases our enforcement ability in some respects. But currently, if community development gets a complaint, it would be a matter of discretion. They might very well go and issue the person a notice of violation. But after that, it's up to the sheriff and the Commonwealth's attorney to do the actual enforcement. This would change it to going through the community development office without involvement of it as a criminal matter, make it purely a civil matter, basically like a traffic citation, rather than giving somebody a criminal record for having an inoperable vehicle, which seems disproportionate. And it would be handled through Nicole's office and through myself. And I have to say, John Alexander is a very nice man. He is not a very nice man with criminal prosecutions. I tend to be a lot nicer in some senses. So it really makes this simpler and more of a reach an agreement to get something done, to get a property fixed when you're getting community complaints process, rather than a process that's built around a criminal prosecution.
I noticed one of the comments in the package, not comments, but points, was there was something like 569 or some such number citations, I guess, and none of them went to court.
No, those were the number of complaints that we received. We resolved every single one of those outside of court. Now, at times we have to potentially, once we've gotten to a point, we have one particular property in a residential area that is part of a homeowners association in the county that had 10 grass complaints over the course of 5 years. At that point, there are times when we will secure someone to mow the property, bill the property owner, and then place a lien on the property if it's not paid. But again, these are extreme cases. They're very typically resolved within 1 to 2 phone calls.
Did we eliminate the penalties?
We did not.
But there's no new hires,
No new hires.
no new hires. Okay. So we're just streamlining this ordinance that we've been doing for years.
Yes,
Same
sir.
rules, different office.
It's the same office. It's just very clear that we also have the
You have
authority
a
to regulate it.
authority, which is agent in here, which
Yes.
makes everyone think that it's a person, but it's the agency to carry out.
That's a great way to put it. Absolutely. I'm sorry, can you repeat the? If we would not be able, and we have not started the process. We have the tools in our toolbox to issue what Mr. Lockaby refers to as civil citation. That's more like a ticket in the zoning ordinance as well. It is another tool in the toolbox to help to get to compliance. It's not a means of, securing revenue or anything like that. As a matter of fact, other localities actually do charge administrative fees for working through a lot of these complaints. We do not. So again, another tool in our toolbox to be able to issue citations to keep folks out of court, which is a costly and lengthy process for someone who might be in violation as well as for the county.
Thank you.
Okay, folks, we have discussed this as if we had already had a motion and a second. If there's no further discussion, we're kind of behind our normal procedure here, but do I hear a motion for approval or disapproval, whatever? Is there a motion to proceed with this revision?
Yeah, I think we need to do it. I move to approve.
It's been moved that we do so. Is there a second?
I'll second.
Okay. Ms. White has seconded it. Further discussion?
Mr. Chairman, the preponderance of people at my town halls as well as the residents, seem very content with the status quo. And they're concerned that this could be used in a sort of a dispute between neighbors and use this as a lever to say, okay, I'm going to turn you in, and now the clock starts ticking on you. So, it's been referred to as a county homeowners association.
What association?
Pardon me?
Please.
A county homeowners association.
Oh. It's been referred to an HOA, is that what you said?
Yes.
And what is the point of that?
But they can do that.
They would have no authority
They-
over.
Nicole, can't they do that right now?
Absolutely.
I mean, it's no difference between
I'm
right
just
now.
saying they're liking this legislation to a county HOA.
They can do that right now, correct?
Right. And the penalty is at this point, as Mr. Lockaby was saying, is criminal misdemeanor.
I know I've had constituents that have called me about properties, and I've called you and you've said, call
You have
the sheriff's department.
administration of 10 years.
So I think nothing's changing
Well,
there,
it's still.
in my opinion.
Well, HOAs only cover a minor part of the county. Right? This wouldn't.
For ag, doesn't touch ag. It's only residential businesses and commercial.
What?
In other words, they can't go after counties.
No, not all of them. That's up to the subdivision.
On that comment about HOAs, they only cover a very small percentage of the county, and a lot of them aren't very functional. So. My comment.
Okay.
Yeah.
Thank you.
Okay. Moved and seconded. Ready to vote? All in favor of proceeding with the amendments, please indicate by saying aye. Aye. All opposed?
Aye.
Motion carries 4-1. Thank you, everyone. And Ms. Pendleton, I think you're still up. Apex.
My apologies for running away. I believe that in your packet, the agenda item mentions that we don't have any significant updates. We continue to coordinate with the folks from Rocky Forge and just are continuing to hear that they are, continuing to work through things. They do not have any updates. We have not received anything formally at this time.
Do you have any idea when you expect to get package back from them?
So I do believe we are working towards an in-person meeting scheduled, and I imagine at that point in time, we'll probably have more information about when we can expect a formal resubmittal of the outstanding packages. You're welcome.
Thank you. That concludes the scheduled agenda items with the exception of general comments from citizens, non-agenda related, and board member comments. So citizen comments, we have 3 or 4. And the first one is Percy Bolton.
Courthouse, where we stand. What are your plans with the Breckenridge Law Office and the price tag quoted in the paper? Does that include the parking lot that was proposed? Where do we stand?
Where's our county administrator? Stand by. We'll get the man with all the answers on that.
Mr. Chairman, it might actually make sense for us to have a comprehensive update on what's going on with the courthouse at a future meeting, and perhaps we can take that
Future
into
meetings.
consideration to
Yeah.
give a more general and full answer of what's going on. There is a lot going on, but at the moment, it's a little bit like a duck. It's all going on underwater. But we can certainly put that out in a more comprehensive format.
Can you provide, and I know you're not saying you have the information, but I'd like to get at least a brief update. while
Well,
the gentleman's here.
Currently, we're getting ready to, we're currently finalizing the construction contract language and the designs for the project manual to be able to put out the package B work, as well as, again, this is not fully decided yet, but also most likely the remainder of the package A work. The package A work being the remediation of any issues that are remaining from the work that's already been done on package A, as well as completing the relocation of the law office hotel structure. We would be using the same contractor whom we had previously pre-qualified to be the sub to do moving of the courthouse or of the law office hotel. Of course, there are no guarantees in the world, but they are considered to be the best in the eastern half of this continent at it. So what else can you do? And so that would be put out to bid, we would guess within the next month or two. Again, you know how it is when you're trying to finalize a project manual on a project that's going to be more than $25 million, most likely, for the winning bid. So, but that's where we are. We're planning on doing that in the near future. And that's all I have right off the top of my head. I think you'd need to have Gary or Rich Evans really go through the details of what it is from the operational side. But right at the moment, myself, Rich Evans, David Mormon, and our architects are all working on this pretty hard.
Okay, thank you, sir. Is it fair to say within 8 weeks, we'll probably 6 weeks, we'll see some activity on site?
Yes, and for what it's worth, we did pre-qualification of bidders, and all of the 4 firms are big heavy hitters, all of whom we're very confident in their ability to do the project. So really, we just need to make sure that we have the contract documents buttoned down to a T so that we're where we need to be. Right.
Good. Mr. Bolton, Go
You
ahead.
say we're going from 30 million to 45 million?
Before there's activity on the site, I would say probably 60, just to be safe.
I said 25 for the remaining work would be something like that. The work that's already been done is going to wind up being a little over 3. So we don't know yet, because that's the nature of bidding. You don't know until you actually get the bids in. It's at least a $25 million project for the remainder of the work, but we anticipated that from the beginning. When we anticipated it being between a $30 and $35 million project.
Yeah. So we will take Mr. Lockaby's suggestion, and just like we have monthly updates on the Apex project, we'll have monthly updates on the core project, Mr. Bolton. Next is Sharon O'Donnell. Still here? Yeah.
Let me step back a little bit. I'm Sharon O'Donnell, and I live on Jay Ridge Road in Cloverdale. And as many of you know, because there's been lots of people that have come before you, Jay Ridge Road is the road that gets all the after-school dismissal traffic from the parents. And I know I was here a couple of months discussing how they block the road, how when there are people in the neighborhood that have work that's going on in their homes and yard, that we have basically been told we're expected to have that stop, excuse me, for the time frame of that dismissal from about 2:45 to about 3:30. And as we know that school's going to be starting in another couple of weeks, this may be the best time to alert the school once more about how they need to change that traffic pattern, because we can't continue doing this. And I know in a month or so, I'm going to be having some work done in my house. And I know that the contractor will not stop for 45 minutes every day. And I don't think we should be expected to have that done. One of the suggestions that I would have is, why can't the traffic just kind of go into the parking lot there at the sports field and wait there until time for dismissal, instead of waiting and blocking Jay Ridge Road? Mornings, it's tough sometimes to try to get out, but you know, the traffic does eventually move. Why can't we do that in the afternoon, to have them stage in the parking lot there? And then when it's time for the school to be dismissed, they can come straight in, straight up to the school, around and back out the road. You know, the other thing is, there's only one means of access to the school. There's only one means of access to our homes, and that's coming up Orchard Hill Road. Should there be an emergency at the school, there is no way that they would be able to get enough support there, because, you know, with all the kids carrying phones, the first second anything happens, they're going to be calling parents, and parents are going to be rushing in. The school, you know, from having taught at Radford University, I know that it's the responsibility of the school to alert faculty, to alert everyone to means of egress from the school, from the building. And it seems like that's all the school is interested in, is getting the kids out of the building. And once they are across the road looking at, you know, off the school property, nobody cares.
Has there been a dialogue with the school board?
Mr. Chairman.
Has there been a dialogue with the school board?
Mr. Chairman, yes, we've had discussions with the superintendent as well as the school principal. And it was fixed for a short period of time. And then it came back up again. And I guess the biggest thing is that some of these citizens in the area that she's talking about presently, one of them had tried to veer off and and missed one of the cars, tipped the car over, and it was one of the citizens' children that turned the car over. So this is a problem. I'm sure that it goes fairly quickly and moves, but what these all are some of the older citizens that are in it. And I don't mean to sound awful, but they are, citizens that have been there for a long period of time. And I think that it desires another discussion with our superintendent. So she has come here twice. We've had a couple other individuals come in here as well throughout the years. So really, we need to go ahead and try to get to the school board as well as the superintendent for that area. So we'll do this again.
I guess Ms. O'Donnell's correct in that this would be a good time while school's still
Yeah.
out.
A couple of years ago, when my husband was ill, I actually met with the school superintendent. He came down and looked at the traffic, but he came early. And, well, this doesn't look all that bad. And by the time everybody got backed up, he was already back up to the school. So, yeah.
Thank you for bringing that here. And I agree with Dr. Scott Horn. There needs to be a facilitated discussion with the school board. We can't we can't change the traffic patterns, but we can certainly talk with them and try to reach consensus on the best solution. I think it's a very valid situation that you bring. Thank you.
Next is Renee Wilhoit. Same topic, so.
Yes. Hi, I'm Sharon's neighbor, and so I obviously deal with the same thing that she does. And obviously there is a big population of older folks in the neighborhood, but some of us have kids and dogs. And also, not only are these people blocking our driveways for people who do have medical needs, there's people with peanut allergies, bee allergies. I have 3 kids. They could, hurt themselves at any moment. And it is a concern that medical personnel, fire EMS, won't be able to get in to assist us. And like Sharon said, if there's issues at the school during that time, it's probably going to be very difficult for them to get in there. Again, we've had work done, and I've been so courteous to call the school and say, hey, I'm having my driveway redone. There's 6 work vehicles that are in the road. Now, granted, I live on the opposite side from where the traffic stops, but that means now that all the cars have to go around, and they just didn't seem to be too concerned about it. We were lucky that there was no accidents, but several years ago, a gentleman's in the neighborhood dog was hit during this car line, and the person did not even stop to slow down, Like I said, they also turn around in the driveways. I have kids and a dog who that's their driveway. Unless I say, hey, someone's coming over, they don't think about that like a street that they have to stop and look for cars. It's our driveway, Yeah, and I was gonna say, I was glad that fire and EMS and VDOT were here to hear these things as well, because for VDOT's sake, I have called VDOT several times about the condition of our road, because there's hundreds of cars that come in every day, multiple times a day. And I think it should be noted that this is just talking about afternoon traffic. In the morning, there's a 40-minute window from 8 to 8:40 that parents can drop their students off. So the traffic is not as bad in the morning, although several years ago, my son had to jump into the ditch to avoid getting hit by a vehicle. So yeah, it's definitely a big problem, and there's only 2 of us from the neighborhood here, but it affects all of us, and we'd appreciate some assistance and guidance.
Thank you.
Thank you, ma'am. And the last person is Faye Waldron. Afternoon.
Thank you, Mr. Clinton, and to the Board of Supervisors and my rep, Ms. White. I visited you for the first time January 23rd, of this year. And I bought what I thought was a simple matter that I had problems solving for probably 20-some years. And in January, when I spoke, I think the matter was assigned to Mr. Lockaby and Ms. White. I met with them after I followed up in March 19th. And in that meeting, I thought we did come to a resolution, even though what we talked about for quite a while during the meeting were things that did not have anything to do with the issue at hand. And to repeat, the issue at hand is my family purchased property in 1982 on Route 11, just north of the gas station. And it's lot 21. That's what my family purchased. Botetourt County assigned lot 22 to my family. And it was a clerical error or an intentional error, I don't know. But I didn't realize it until I talked to Drew Pearson, and he let me know what was going on. He also told me that it wasn't a complicated issue. Drew Pearson was the part of the planning and so forth for the county. It wasn't a complicated issue. He was working 2 issues like that himself at the time. When I met March 19th with Ms. White, she said her family had a similar issue. So my issue is not complicated, but it's not been resolved. I've gotten no contact saying that they have switched my property number, my parcel number, to lot 21 as my deed indicates. And it's been 6 months now, and I have no action on it. I want the board to actually take action, and a righteous action, and putting that land back in my family's name and letting me move on to improve it. The issues that we talked about on March 19th, some of them were so far-fetched, it's not even really worth mentioning. But something like going back 2 centuries, the town of Buchanan should have put that entry in the plat book, and they did not. It had nothing to do with me. That's another government problem. We talked about that. We talked about my family, which I think I was the only one in the room that knows my family and the deeds that they have signed, turning over their property to me, which I did not bring up. And the other thing was that my neighbor next door, that was brought up in the meeting, had a similar problem because of something that happened, a couple of centuries ago. So I'm not sure what the holdup is, but I would like your resolution.
And it's an issue of the actual configuration of the tax parcel, the actual lot.
It's not even the configuration. It's just, I have lot 21 and they put on my tax parcel lot 22B.
Mr.
My
Chairman,
deed says 21.
Mr. Lockaby's done a lot of research on this.
Well, I first want to apologize that no one reached back out to you with the result of the research that I did. I did some research and circulated it. Typically, I only reach out to lawyers to talk to them, and I apologize for not having followed up on that. As far as the status of the matter, there was, going all the way back, there was a property. These 2 lots, which are right next to each other in the town of Buchanan, that were in the original plat of this area of Buchanan. One of those properties has been, and this is the big part of the issue, it's been illegally subdivided twice in the last 50 years. And those deeds, the descriptions in those deeds don't match up to anything. So you've got that issue. You've also got the issue that somebody went and filed a case in court, which resulted in a judge saying that somebody else owns the property that probably belongs to her, but I don't wear a black robe and I'm not capable of saying that in any meaningful sense. So the issue is that really, in order to figure out where these illegally subdivided parcels are, which at this point it's years back and nobody's going to try to go after whatever lawyer prepared those deeds improperly, but they are what they are at this point, but it's almost impossible to figure out where they are without having a survey done. My understanding is that Chris Booth, who of course, I wish he were still here, who is of course the custodian of the tax maps, he's a little bit concerned about his going and ordering a resurvey of this property and ordering a professional title search of this property in order to figure out who actually owns it, and whether that leads to next time we have an issue of similar type where there's a property with fouled up boundaries, we wind up being the people who have to bear the cost of the survey and the title search. And Ms. Waldron may still wind up having to file a quiet title action in order to get the clouds on the property's title straightened out. So I've just said a lot of words. The bottom line is that the title to this property is very tangled. What was one property going up till about 1970, I can't remember exactly the year when it took place. It was one piece of property going up to about 1970. And after that, it got subdivided into 3 by deeds that are not clear. There is ownership by several people that I can't figure out who they are, what happened to them because of the wills. What ultimately comes down to is I can prove pretty well that the tax map is wrong, but without ordering a professional survey and a professional title search, I can't prove what's right. And the question is whether it's the county's responsibility to order that survey and title search, or whether it is one of the landowner's responsibility to order that survey or title search. And I think that the perspective that county staff and the Commissioner of the Revenue have taken is, Ms. Waldron, please give us a plat that's stamped by an actual surveyor and we'll sort this out. But that the county's not going to spend $1,000 on this plat, which not a huge amount of money for this particular plat, but the next plat, it's a 250-acre parcel with much more complicated easement issues that winds up being a $5,000 or $10,000 plat. It's just a slippery slope that they aren't comfortable with. That's all I'm comfortable speaking on behalf of other people. I'll let Ms. Pendleton and Mr. Booth speak on their own behalf further with that.
And it was my understanding someone was going to follow up with you. I apologize that we haven't, but this will bring it back to the forefront and we can have a discussion about how we might resolve this. It's very tangled.
Yeah.
Unfortunately tangled.
This is in the town.
It's in the town limits as well.
Maybe they ought to pay for the survey.
I'd like to say no matter what the land was, I've done a unofficial survey and I've sent it to Ms. White that shows where my borders are. I don't believe I'm responsible for surveying the other pieces of the land when my deed clearly says that the land is divided into 2 parts. I don't know where the 3rd part comes in, but the lot 21 was divided into 2 parts at the time that my uncle purchased it. I don't know about 1970, but my deed clearly says that. And so all I'm asking for the board to do is to respect my deed. And I understand that the other properties need surveying, but not at my expense. And I do understand that the county made the error. If they had actually filed my deed with the proper parcel number, not a 22, because there's nothing in my deed that says 22. My deed says 21, and it's very clear. My deed has been surveyed unofficially. I know where my borders are. The other ones are not my issue. What happened with, the town government, that's not my issue. I want my issue resolved. And whoever else has the property, beside me and around me and all of that, that's their issue. And it's Botetourt County's issue, really, for letting this issue linger for so long without resolution. And I know I've only brought it to you 6 months ago. So given that, yeah.
What do you mean when you say it's been unofficially surveyed?
Well, I sent my deed to Balzer and Associates, and I asked them to map out where my borders are based on the deed. And they did that. And they sent it back to me, and it's exactly, the property that I've been owning and working on for the past 22 years. My deed is correct. The property lines are correct in my deed. The survey verifies that. I don't see any confusion with my property. Where the confusion lies is Botetourt County putting wrong numbers on other people's property, including mine, and then not rectifying their error or their whatever it was. That's the only thing that's outstanding here is Botetourt County taking responsibility for putting the wrong parcel numbers on it in 1982.
Have we had offline discussions with, well, you and community development and whoever would be involved in this?
I've had some conversations with Ms. Pendleton's office and was with Mr. Booth's office. The Balzer drawing is actually an overlay of just a colored box onto the GIS map. So, and their guess is roughly the same as my guess, but it goes back to that 1982 deed that illegally subdivided the property, which I don't think anybody's willing to argue with it now, but it wasn't surveyed, and somebody in the clerk's office or commissioner's office who was not a surveyor made a guess. And the guess was probably wrong, but I don't know what's right.
Are you saying that my deed doesn't show that it was surveyed?
It doesn't.
It gives coordinates that.
It gives meets and bounds, but they're not clear. And you have to, in order to subdivide property properly, you need to record a survey.
Right. I'm not sure if that was something that was not done, and I really don't believe that was something that was omitted when my uncle purchased the property, basically because he has the survey coordinates in the deed. So someone, again, in Botetourt County did not record it properly. I can't take responsibility for that. I've done my due diligence. I've worked around Buckhannon to clean the property when they had it blocked in and everything. Anybody that drove by Route 11 knows that what you see now is nothing like it was 2 years ago, because 2 years ago, it just looked like a forest out there. I had all those trees cut down. I had the property cleaned up. And now I just want to renovate the building, which is on the African American Historical List. It was a place where my father and his brothers met for the Masonic Lodge. I want to renovate it. I want to make it respectable. But this roadblock that I'm getting because Botetourt did not record the deed properly. That's all that happened in 1982. And everything that happened subsequently is because Botetourt County did not record the deed properly with the right parcel number.
If that can be demonstrated, and I gather that it can be, my inclination is we try to fix it. I hear what you're saying about precedent, but how likely is a similar precedent? Especially in terms of scale.
That's why I'm kind of, I wish Mr. Booth were here in order to ask him how often this type of issue comes up through his office. Typically, it's going to come up through his office. Sometimes through Nicole's office, but more frequently through Chris's.
More frequently.
Through Chris Booth's office.
Have you spoken with the circuit court clerk at all regarding this?
I've spent hours and hours. Yes, we're almost close.
Okay. Y'all close now.
It should be close.
Gotcha.
As much time as I spent there and in Buckhannon, because before I brought this issue to you, I did thorough research. I had several suppositions before I came to you, and I resolved all those and found out what the real problem was based on the Balzer Associate, which really put the clincher in it, that the deed just wasn't recorded properly when the deed was executed. Lot 22 is not what's described here. It's lot 21 in my deed. It says the borders are lot 22. The borders to my land is lot 22 and lot 20. The only thing it could be is lot 21, besides the fact that it says that specifically in my deed. And the other part of the land is referred to in my deed.
Take a look at
The
So,
part that was separated is
Mike,
referred to on
share.
page 2 of my deed, saying that my uncle had first right of refusal for this other little piece of the land of lot 21 that he did not buy at the time, which is basically just a lot with no egress.
Mike, can you share with the board your research that you did? I mean, probably not right now, but let everyone look at that
Yeah,
and
I
we
can
can
forward that to
then
you.
try to figure a path forward. I wish Gary was here too, because I thought he was involved in the conversation.
Chris.
And get Chris involved as well. We need to pull Chris in to another conversation, but Ms. Waldron does have extensive documentation, and when we met initially on this, she has a lot of documentation, a lot of history.
Yes.
It would be fantastic to clean this up because that property would be beautiful to be renovated and
Yes.
bring it back to its glory days. It would be a real asset to the community if we could get this resolved. I'm totally in favor of that.
Thank you.
so we're proposing a meeting with the county attorney and
Chris and me and one of you all.
Yeah,
Maybe Nicole.
And Nicole.
Nicole,
And
yeah.
yeah,
Sure.
Can you set that up, Laurie? Just
Thank you.
Thank you.
thank
keep
you.
the step.
Thanks for bringing it back.
That's all the citizen comment requests we have. Board member comments.
Right.
Any board member comments?
I will just point out, 2 exciting weekends coming up in Buchanan. This weekend is the annual Tomato Festival. And next Saturday is the annual Botetourt County Agricultural Fair. So we will have 2 very big, hopefully well-attended and wonderful events. So please come and join us at those.
The second one is where?
They're both at the Buchanan, at the town park. Yeah.
Very good. Always something happening in Botetourt. Anything else for the good of this body? I'll entertain the motion to adjourn. I second it. All in favor indicate an aye. Aye. Opposed. We are adjourned. Well, we're adjourned. We'll be back in session at 6 o'clock.
Yeah.
Because
Public hearing.